Hey guys, it's Maddie. Welcome back to my channel. In today's video, I'm going to be doing the part 2 of the Casey Anthony case. I'm going to be talking about the investigation and the aftermath of the whole thing. So if you didn't see part 1 of this video, go check it out before you watch this one. So if you want to continue watching, then do so and like this video. Comment down below what other cases you want me to do, and let's get on with the video. Okay, so for the investigation, and if you see me looking down, I have notes on my computer, so that's why. Detective, I don't know how to say his name, Yuri Melich of the Orange County Sheriff's Department began investigating Kaylee's disappearance. He found a lot of different things wrong in Casey's signed statement that she did. When she was questioned, Casey said that Kaylee had been kidnapped by Zenaida Fernandez Gonzalez, which was also identified as Zanny, which was Kaylee's nanny. Although Casey had never talked about her before, Zanny had never was seen by Casey's family or friends, and there really wasn't any type of nanny. Casey also told police that she was working at Universal Studios, which was a lie that she's been telling her parents for years. Investigators brought Casey to Universal Studios on July 16, 2008, the day after Kaylee was reported missing, and asked her to show them her office. Casey led police around for a while before admitting that she had been fired years before. Casey was first arrested on July 16, 2008, and was charged the following day with giving false statements to law enforcement, child neglect, and obstruction of a criminal investigation. The judge denied bail, saying Casey had shown willful disregard for the welfare of her child. On July 22, 2008, after a bond hearing, the judge set bail at $500,000. On August 21st, 2008, after 1 month of her being in jail, she was released from Orange County Jail after her $500,000 bail was posted by her nephew of California, in hopes that, she would cooperate and Kaylee would be found. On August 11th, 12th, and 13th in 2008, meter reader Roy Kronk called police about a suspicious object found in a forested area near their home. At first, he was directed by the sheriff's office to call the tip line that they had set up, which he did, and they did not return his call. On the second chance, he again called the sheriff's office, eventually was met by 2 police officers and reported to them that he had found a skull which was in a trash bag. And it was like a gray kind of bag. I don't know if it was a trash bag, but it was some sort of gray bag. On that occasion, the officer conducted a short search and stated he did not see, what is it called? Where am I? I just lost my train of thought. And he did not see anything, so there's that. And then on December 11th, 2008, Kronk again called the police, and they searched and found the remains of a child in a trash bag. Investigative teams recovered duct tape, which was hanging from hair, which was attached to the skull, and some tissue that was left on the skull. Over the next 4 days, more bones were found in the wooded area near the spot where the remains initially had been discovered. On December 19th, 2008, medical examiner Jan Garavaglia confirmed that the remains were found those of Kaylee Anthony. The death was ruled homicide and the cause of death listed as undetermined. Now I want to talk about the arrest and charges of Casey Anthony. So Casey was offered a limited immunity deal on July 29, 2008 by prosecutors related to the false statements given to law enforcement about locating her child, which was renewed on August 25th and expired on August 28th. She did not take it. On September 5th, 2008, she was released again on bail on all pending charges after being fitted with electronic tracking device. Her $500,000 bond was posted by her parents and her family, like with her cousin and all that, Cindy and George Anthony, who signed a promissory note for the bond. On October 14th, 2008, Casey Anthony was indicted by a grand jury on charges of first-degree murder, aggravated child abuse, aggravated manslaughter of a child, and 4 counts providing false information to the police. She was later arrested. Judge John Jordan ordered that she should be held without bond. On October 21st, 2008, the charges of child neglect were dropped against Casey, according to the state attorney's office, because as the evidence proved that the child was deceased, the state sought an indictment on the legally appropriate charges. On October 28th, Anthony was arraigned and pleaded not guilty to all charges. And then on April 13th, 2009, prosecutors announced that they plan to seek a death penalty in this case. Now I kind of want to go into the trial and like the evidence and all that. So 400 pieces of evidence were presented in court. A strand of hair was recovered from the trunk of Casey's car, which was, similar to hair taken from Kaylee's hairbrush. The strand showed root banding, in which hair roots form a dark band after death, which was consistent with hair from a dead body. And then Kronk, who discovered the remains, repeated the same basic story that he told the police when he first found the remains. On Friday, October 24th, 2008, a forensic report by Arpad Bass of the Oak Ridge National Laboratory judged that results from an air sampling procedure performed in the trunk of Casey Anthony's car showed chemical compounds consistent with a decompositional event based on the presence of 5 key chemical compounds out of over 400 possible chemical compounds that Bass's research group considers typically of decomposition. Investigators stated that the trunk smelled strongly of human decomposition, but human decomposition was not specified on the laboratory scale. The process has not been affirmed by a Daubert test in the courts. Bass's group also stated there was chloroform in the car trunk. In October 2009, officials released 700 pages of documents related to the Anthony investigation, including records of Google searches of the terms neck breaking and how to make a chloroform on a computer which was accessible to Casey, presented by the prosecutors as evidence of a crime. According to detectives, crime scene evidence included residue of a heart-shaped sticker found on the duct tape over the mouth of Kaylee's skull. However, the lab was not able to capture like a heart-shaped photographically after some of the duct tape was subjected to dye testing. A blanket found at the crime scene matched Kaylee's bedding at her grandparents' house. Among the photos entered into evidence was one from the computer of Ricardo Morales, which is an ex-boyfriend to Casey Anthony, depicting a poster with the caption "Win her over with chloroform" was in the picture. Witness John Dennis Bradley software developed for computer investigations was used by the prosecution to indicate that Casey had conducted extensive computer research on the word chloroform 84 times and to suggest that Anthony had planned to commit the murder. He later discovered that a flaw in the software misread the forensic data and the word chloroform had been searched for only one time, and the website in question offered information on the use of chloroform in the 19th century. So now I'm going to talk about the attorneys and the jury. So the lead prosecutor in the case was Assistant State Attorney Linda Drain Burdick. Assistant State Attorneys Frank George and Jeff Ashton completed the prosecution team. Lead counsel for the defense was Jose Baez, a Florida criminal defense attorney. Attorneys J. Cheney Mason, Dorothy Clay Sims, and Ann Fennell served as co-counsels. During the trial, attorney Mark Lipman represented George and Cindy Anthony. Jury selection began on May 9, 2011 at the Pinellas County Criminal Justice Center in Clearwater, Florida, because the case had been so widely reported in the Orlando area. Jurors were brought from Pinellas County to Orlando. Jury selection took longer than expected and ended on May 20th, 2011, with 12 jurors and 5 alternates being sworn in. The panel consisted of 9 women and 8 men. The trial took 6 weeks, during which time the jury was sequestered to avoid influence the information available outside the courtroom. So now I want to talk about the opening statements. So the trial began on May 24th, 2011 at the Orange County Courthouse with Judge Belvin Perry presiding. In the opening statements, lead prosecutor Linda Drain Burdick described the story of the disappearance of Caylee Anthony day by day. The prosecution alleged an intentional murder and sought out the death penalty against Casey Anthony. Prosecutors stated that Anthony used chloroform to render her daughter unconscious before putting duct tape over her mouth and nose to suffocate her, and left Caylee's body in the trunk of her car for a few days before disposing it. They characterized Anthony as a party girl who killed her daughter to free herself from a parental responsibility and enjoy her personal life. The defense, led by Jose Baez, claimed in opening statements that Caylee drowned accidentally in the family's pool on June 16, 2008, and was found by George Anthony, who told Casey she would spend the rest of her life in jail for child neglect, and then proceeded to cover up Caylee's death. Baez argued this is why Casey Anthony went on with her life and failed to report the incident after 31 days. He alleged that it was a habit of a lifetime for Casey to hide her pain and pretend nothing was wrong because she had been sexually abused by George Anthony since she was 8 years old, and her brother Lee also had made advances toward her. Baez also questioned whether Roy Kronk, the meter reader who found the bones, had actually removed them from another location, and further alleged that the police department's investigation was compromised by their desire to feed a media frenzy about a child's murder rather than more of an accidental drowning. He admitted that Casey had lied about there being a nanny named Zenaida Fernandez Gonzalez. So now I want to talk about the witness testimony. So prosecutors called George Anthony as their first witness, and in response to their question, he denied having sexually abusing his daughter, Casey Anthony. Anthony testified he did not smell anything resembling human decomposition in Casey's car when she visited on June 24th, but he did smell something similar to human decomposition when he picked the car up on July 15th. Cindy Anthony testified that her comment to the 911 that Casey's car smelled like someone just died was just a figure of speech. Baez asked an FBI analyst about the paternity test the FBI conducted to see if Lee was Caylee's father. She told the jury the test had come back negative. Regarding a photo on the computer of Ricardo Morales, which is Casey Anthony's ex-boyfriend, depicting a poster with the caption, "Winter over with chloroform." Morales said that the photo was on his MySpace page and that he had never discussed chloroform with Anthony or researched chloroform on his computer. The prosecution called John Dennis Bradley, which is a former Canadian law enforcement officer who developed software for computer investigations, to analyze a data file from a desktop taken from the Anthony home. Bradley said he was able to use a program to recover deleted searches from March 17th and March 21 in 2008, and that someone searched the website scipot.com for chloroform 84 times. Bradley expressed his belief that some of these items might have been bookmarked. Under cross-examination by the defense, Bradley agreed there were 2 individual accounts on the desktop, and there was no way to know who actually performed the searches. K9 handler Jason Forgy testified that Juris, which is a German Shepherd cadaver dog, certified in 2005, indicated a high alert of human decomposition in the trunk of Casey's car, saying that the police dog had a real-world searches numbering over 3,000 by now. During cross-examination, Baez argued that the dog's search words were hearsay. Sergeant Kristen Brewer also testified that her canine partner Bones signaled decomposition in the backyard during a search in July 2008. However, neither canine partner was able to detect decomposition during a second visit to the Anthony home. Brewer explained that this was because whatever had been in the yard was either moved or the odor disappeared. The prosecution called Chief Medical Examiner Jan Garabaglia, who testified that she determined Kaylee's manner of death to be homicide, but listed it as death by undetermined means. Garabaglia took into account the physical evidence present on the remains she examined, as well as the available information on the way she was found and what she told authorities before arriving at the determination of she just didn't know how she died. There's a quote by her saying, "We know by our observations that it's a red flag when a child has not been reported to authorities with injury. There's foul play. There's no child that should have had duct tape on the lower part of its face when it dies." She also says that she addressed the chloroform evidence found by the investigators in the trunk of Casey's car, testifying that even a small amount of chloroform would be sufficient and to cause death of a child. University of Florida professor and human identification lab director Michael Warren was brought on by the prosecution to present a computer animation of the way duct tape could have been used in the death of a child, which the defense objected to hearing. Judge Perry, after a short recess review, ruled that the video could not be shown to the jury. The animation featured a picture of Kaylee taken alongside Casey, and with the image of Kaylee's decomposed skull, and another with a strip of duct tape that was recovered with her remains. The images were slowly brought together, showing that the duct tape could have covered her nose and mouth. Bias stated, "This disgusting superimposition is nothing more than a fantasy. They're throwing things against the wall and seeing if it sticks," was a quote by him. Jurors were seen taking notes of the imagery, and Warren testified that it was his opinion that the duct tape found with Kaylee's skull was placed there before her body after decomposing, or before it decomposed. FBI latent print examiner Elizabeth Fontaine testified that adhesive in the shape of a heart was found on the corner of a piece of duct tape that was covering the mouth portion of Kaylee's remains during an ultraviolet testing. So Fontaine examined 3 pieces of duct tape found on Kaylee's remains for fingerprints, and said that she did not find fingerprints, but did not expect to find them given the months that the duct tape and the remains have been outside and exposed to the outside elements, stressing that any oil or sweat from a person's fingertip would have long been disappeared. Although Fontaine showed that the findings to her supervisor, she did not initially try to photograph the heart-shaped adhesive, explaining, in quote, "When I observe something is unexpected, I note it and continue with my examination," end quote. So during the defense's cross-examination, Fontaine explained that when she examined the sticker evidence a second time after subjecting the tape to dye testing, it was no longer visible. She said that other FBI agents have tested the duct tape also. So closing arguments were heard on July 3rd and July 4th. Jeff Ashton for the prosecution told the jury, in quote, "When you have a child, that child becomes your life. This case is about the clash between the responsibility and the expectations that go with it, and the life that Casey and Anthony wanted to have," end quote. He outlined the state's case against Casey, touching on her many lies to her parents and others, and the smell in her car's trunk, identified by several witnesses, including her own dad, as an odor from human decomposition, and the items found with Kaylee's skeletal remains in December 2008. He emphasized how Casey, in quote, "maintains her lies until they absolutely cannot be maintained anymore," end quote. and then replaces them with another lie using Zanny the nanny, for example. Anthony repeatedly told the police that Kaylee was with the nanny that she specifically identified as Zenaida Fernandez Gonzalez. Police, however, was never able to find the nanny. Authorities did find a woman named Zenaida Fernandez Gonzalez, but she denied ever meeting Anthony. Ashton reintroduced the items found with Kaylee's remains, including the Winnie the Pooh blanket that matched the bedding of her grandparents' home, one of a set of laundry bags with the twin bag found at the Anthony home, and the duct tape he said was a relatively rare brand. End quote. That bag is Kaylee's coffin. Holding up a photograph of the laundry bag as Casey reacted with emotion. He further criticized the defense theory that Kaylee drowned in the Anthony pool, that Casey and George panicked upon finding the child's body and covered up her death. He advised jurors to use their common sense when deciding on a verdict. No one makes an accident look like a murder, he said. Before closing arguments, Judge Perry ruled that the defense could argue that a drowning occurred due to reasonable conclusions aids by witness testimony, but that arguing sexual abuse was not allowed since there was nothing to support the claim that George sexually abused Casey. Baez began by contending that there were holes in the prosecution's forensic evidence, saying it was based on a fantasy. He told the jury that the prosecution wanted them to see stains and insects that really did not exist, that they had his client look like a liar because the evidence was weak. He said the drowning is the only explanation that makes sense, and showed jurors a photograph of Kaylee opening the home sliding glass door by herself. He stressed there was no child safety locks on the home, and both of Casey's parents, George and Cindy, testified that Kaylee could get out of the house easy. Although Cindy testified that Kaylee could not put the ladder on the side of the pool and climb up, Baez alleged that Cindy may have left the ladder up the night before. In quote, he said she didn't admit to doing so in testimony, but how much guilt would she have known it was her fault? It was her that left the ladder up that day. The jury began deliberation on July 4th. On July 5th, the prosecutor stated during deliberations they were about to give the jury the correct information with regards to Bradley's software discrepancy. However, the jury reached a verdict before they could do so. One legal analyst stated that if the jury had found Casey guilty before receiving the new evidence, the prosecution's failure to fully disclose it could have been grounds of a mistrial. So on July 5th, 2011, the jury found Casey not guilty of counts 1 through 3 of the first-degree murder, aggravated manslaughter of a child, and aggravated child abuse, while finding her guilty on counts 4 through 7 for providing false information to law enforcement. On July 7, 2011, sentencing arguments were heard. The defense asked for the sentencing to be based on one count of lying on the grounds that the offenses occurred as part of a single interview with the police during dealing with the same matter, the disappearance of her daughter, as one continuous lie. The defense also argued for concurrent sentences, that is, for all 4 counts to become one count and the sentence to run together as one. The judge disagreed with the defense's arguments, finding that Anthony's statements consisted of 4 distinct separate lies, ordered the sentence to be served consecutively, noting that, in quote, law enforcement expended a great deal of time, energy, and manpower looking for Kaylee Marie Anthony. The search went on from July through December over several months trying to find Kaylee Marie Anthony, end quote. Judge Perry sentenced Casey to 1 year in the county jail and $1,000 in fines for each of the 4 counts of providing false information to a law enforcement officer, the maximum penalty prescribed by law. She received 1,043 days credit for time served plus additional credit for good behavior, resulting in her release on July 17, 2011. Anthony filed a notice of appeal on July 15, 2011. Following this trial, Mason blamed the media for the passionate hatred directed towards Casey Anthony. He described it as a media media assassination of her before and during the trial, saying, and quote, "I hope that this is a lesson to those of who had indulged in media assassination for 3 years, bias and prejudice, and incompetent talking heads saying what would be and how to be. I can tell you that my colleagues from coast to coast and border to border have condemned this whole process of lawyers getting on television and talking about cases that they don't know a damn thing about and don't have the experience to back up their words or a law to do it. Now you've learned a lesson," end quote. Mason's response was viewed as especially critical of Nancy Grace, whose news program is cited as having almost single-handedly inflated the Anthony case from a routine local murder into a national obsession. Grace said that she did not understand why Mason would care what pundits are saying, and she imagined she has tried and covered as many cases as Mason. She criticized the defense attorneys for delivering media criticism before mentioning Caylee's name in their post-verdict news conference and said she disagrees with the verdict. At a meeting of local professionals named the Tiger Bay Club of Tampa, Mason told the media and those attendants that he was surprised by the not guilty verdict. Since the end of the trial, various movements have been created by a new law called Caylee's Law that would impose stricter requirements on parents to notify law enforcement of the death or disappearance of a child. One such petition, circulated through change.org, has gained nearly 1.3 million electronic signatures. In response to this and other petitions, lawmakers in 4 states, which is Florida, Oklahoma, New York, and West Virginia, have begun drafting versions of Caylee's Law. The law in Oklahoma would require a child's parents or guardian to notify police of a missing child within 24 hours and would also stipulate a time frame for notification of the disappearance of a young child under the age of 12. The Florida law would make it a felony if a parent or legal guardian fails to report a missing child in a timely manner if they could have known the child would be in danger. The call for mandatory reporting laws have been criticized being reactive, overly indiscriminating, and even counterproductive. One critic noted the law could lead to overcompliance and false reports by parents wary of becoming suspects, wasting police resources, and leading to legitimate abductions going uninvestigated during the critical first few hours of a child being abducted. Additionally, innocent people could get snared in the law for searching for a child instead of immediately calling the police. So that is the whole Casey Anthony case. If you want to hear more about Casey Anthony, one of my 2 favorite podcasts cover the Casey Anthony case, and it's called True Crime Garage and Moms and Murder. Give a really good description and just a good story of this case. So if you like true crime, anything or whatever, comment down below if you want me to cover a case. I would be happy to do so, and I hope you guys are staying safe and getting through this hard time, and I will see you guys on Tuesday with my next video. Bye guys.